Welcome to Nasdaq TradeTalks. I'm Jill Malandrino, Global Markets Reporter at Nasdaq. Joining us for this segment, we have Kayvan Ghaffari, General Counsel at MakersPlace, to discuss legal implications and considerations related to likeness and intellectual property in Web3. Kayvan, it is great to have you with us. Welcome to Trade Talks.
Hi, Jill. Great to be here, and it's an honor to speak with you. Thank you.
You got it. Tell us about MakersPlace.
MakersPlace is a premier digital art platform. We sell digital art to customers and collectors all over the world. We kind of, we're a 5-year-old startup and, really been innovative in the digital art space. Some may say NFTs. We're trying to use the word digital art because we really believe in the artistic vision of our creators and the artistic collections that our collectors are maintaining. We kind of, catapulted to fame in 2020 with Beeple's first 5,000 day sale with Christie's for $69 million. That sale kind of catapulted the NFT digital art space. And we've been really enjoying this space, working with artists on a daily basis, really trying to bring their vision and creativity to life in a pretty material, new and profound way.
What are the legal implications and considerations in the Web 2 and Web 3 to Web 3 transition?
Sure, it's a great question. I think there's a variety of things that any company must think about in terms of transitioning from Web 2 to Web 3. One is just the regulatory uncertainty right now. The alphabet soup of government agencies are having, at least in the United States, are having some challenges trying to understand and grapple with this new Web3 paradigm. And we're seeing a lot of these agencies kind of competing against one another in terms of who can control and regulate the space. Add on top of that, the global regulatory framework creates a little bit of confusion within just the ecosystem. And while a lot of companies are calling for greater regulation, that is something that brands and companies need to think about. In addition, with respect to digital art, brands and companies need to think about, the traditional stuff like IP infringement, trademark, copyright, right of publicity, likeness, and think about those from a different global lens, especially with, the rise of artificial intelligence technology and AI art. Those are going to be things that I think companies are going to have to grapple with.
What's the impact of recent legal decisions on AI and art?
Sure. I think one of the most impactful decisions recently is the Andy Warhol decision that the Supreme Court just came out with a month or so ago. In that case, the Supreme Court said that Andy Warhol's Warholified Prince picture was not fair use, given that the Warhol estate had a license to Condé Nast. And I think the impact of that is, under copyright law, there's a doctrine called fair use, and fair use enables people to kind of use pre-existing content and expression to further creativity. Because while the Copyright Act does provide, a limited monopoly to a creator, there is a balancing act with just the right of the public's right to continue to create and innovate. And so with respect to the Warhol opinion, I think there's no question that Warhol was a significant artist that really transformed art. But the Supreme Court really did not care about the transformative nature of Warhol. Instead, it really just focused on a single license about a single photo that was given to Condé Nast. And I think that's problematic because it's really stripping away the creative aspect of copyright law and really turning copyright law into a transactional kind of exchange. And I just, I'm personally concerned about that impact on artists, because artists no longer have the freedom to kind of recreate existing content in a new and transformative artistic way. And so I think a lot of artists are probably wary now as to what they should do with pre-existing materials.
Yeah, it kind of doesn't make any sense when you think about it in terms of academic research. You're constantly citing prior work because you want to build on the research that already exists. That's the foundation of science and how not even just science, but how we advance all the disciplines. So it kind of sounds similar to me if you're going to continue to advance on what artists have done prior to, assuming that you're attributing correctly and, all your I's are dotted and T's are crossed, but it's essentially what you do in academia. So I don't understand why in artistry, it doesn't work the same way.
I could not agree more.
What about IP in the context of AI and NFTs? Who owns the work and how do you determine originality?
That's a very good question. And I think it depends on what jurisdiction you're in. So in the United States, copyright law is pretty clear that, a human has to create the expression in order for it to be copyright eligible. And I think what we'll start to see is a paradigm or an analysis as to the extent by which the creator is actually creating the art as opposed to the algorithm. And I think you're going to get into questions of, well, how far away from the algorithmic output did this creator go? And within that framework, well, what can we discern that was created specifically from the algorithm versus the human expression? And we may see the Copyright Office say, well, just that human expression aspect of it is owned and created by a human and therefore eligible for copyright infringement. Now, in the United Kingdom, very different story. Any AI output is copyright eligible. And so, there is this question of, well, if I'm an artist, maybe I'll fly to the United Kingdom, create some art, have protection, come back to the United States, it would still be protected under the Berne Convention, which is a treaty that enables all countries to respect copyright laws.
So clearly there's been a challenge, and you mentioned this at the top with coming together with global standardization, as we see in Web2. We know the intermediaries like Google, for example, it's a US company, it's operating in countries around the world. They're going to have different sets of rules as it relates to content moderation, data privacy, e-commerce, right? So if we're having challenges with centralized intermediaries, do you think centralization is going to create even a bigger challenge as it relates to legislative standards and regulation?
I think it will create challenges for regulators. And I think that's because regulators have been working in an intermediary centralized ecosystem for decades. And this is a huge paradigm shift in which you're removing that intermediary. And I think regulators are having a difficult time or struggling with, well, how do I respond to this? What do I do? And so I think from a business perspective or a company perspective, the most important thing to do is just keep tabs on legislative developments across the world and chime in whenever you hear of public comments. For example, in the United States, the Copyright Office has been at the kind of the forefront of AI tools. And they have been since, October of last year, have been calling for public statements on, what should we do with AI art or AI technology? Should it be copyright, patent, and trademark eligible? And unlike other agencies in the United States. And so being a participant in those conversations is going to be critical to the overall ecosystem's health and ability to kind of inform what the regulation should be.
I feel like the EU has a better grasp on this. I mean, you have the Digital Service Act, the DSA getting implemented in 2024. We just had the MiCA legislation as it relates to digital assets. I feel like there's a way that we could probably take some elements of that in addition to, the current legislation that we have. It just feels a little bit more structured over there.
I could not agree more. They are doing something right, and we just need to really, we need to get our act together in this country, or else I think there's going to be a pretty big shift in terms of where companies are going to be located.
Well, exactly. You don't want that innovation to be offshored because clearly we're not reverting back to Web2. We're kind of moving forward with these newer technologies.
Absolutely.
Right. Appreciate the insight. Thanks for joining us on Trade Talks. I'm Jill Malandrino, Global Markets Reporter at Nasdaq.
Thank you.